Once a person has been convicted of a criminal offense, one of the first things they think of is how and when can they get this conviction off their record. Having heard of the word expungement, they seek to know whether they themselves can have their conviction expunged. Unfortunately, Arizona does not have formal expungement, but has a set aside process where the conviction is set aside and the person is released from all penalties and disabilities of the conviction. The statute that details the process of setting aside a conviction is found in Arizona statutes and states. A. Except as provided in subsection K of this section, every person convicted of a criminal offense on fulfillment of the conditions of probation or sentence and discharge by the court may apply to the court to have the judgment of guilt set aside. The convicted person shall be informed of this right at the time of sentencing, because driving under the influence, DUI, is not one of the excluded offenses. An individual can apply to have their DUI conviction set aside. An individual can seek the set aside once they have completed any probation ordered and paid all the fines, fees, and other court requirements. To get the conviction set aside, the person's attorney, or the person's probation officer may apply to set aside the judgment. Unfortunately, because the way the laws are in Arizona, a DUI conviction will always be on a person's record and will not be able to be removed. However, the set-aside process does have various benefits that are worth the time to seek it. Doing so allows the person to declare to future employers and other parties that the conviction has been set aside and that they have been released from all obligations and penalties resulting from the offense. For misdemeanor DUIs, or regular extreme or super extreme offenses, the individual will receive more jail time, greater fines, and harsher penalties if it is their second DUI committed within 84 months of the date of the prior offense. If it is the driver's third DUI committed within 84 months of the first offense, the driver will be charged with aggravated DUI, which is a Class 4 felony. This carries a mandatory 4-month minimum prison term, greater penalties, and a felony conviction on record. The process to set aside a conviction can be confusing and stressful. Having the right attorney to help you understand the process and file the application with you is key to success. At Phoenix DUI Lawyer, you have a dedicated team that has successfully set aside convictions for a number of clients and know the best path for success. Call the Phoenix DUI Lawyer Criminal Law Team at 602-900-9891 to get expert-level legal help with your case.